Under section 99, who may give evidence of agreement varying terms of a document. Section 92 forbids the admission of evidence of an oral agreement for the purpose of contradicting, varying, adding to, subtracting from the terms of the written document as between the parties to such documents or their representative in interest. The rule of exclusion laid down in the section does not apply to the case of a third party who is not a party to the document. On the contrary, this section distinctly provides that a person who is not a party to a document may give evidence tending to show a contemporaneous agreement varying the terms of the document. The principle of section 92 does not apply to a third person. If it were otherwise, third person might be prejudiced by things recited in the writing contrary to the truth, though the ignorance, carelessness, or a fraud of the parties, and therefore ought not to be precluded from proving the truth, however contradictory it may be to the written statement of the other. Section the words varying only is used, while in section 92 the words are contradicting, varying, adding to, or subtracting from, but it is difficult to see that in using the term varying only, anything less could have been meant than what is conveyed by the several expression in section 92, and as every contradicting, adding to, or subtracting from would necessarily be a varying of the instrument. The legislature apparently used that expression as sufficient to convey all that is denoted by the other different expression occurring in the particular section, in the earlier section. The plaintiff sued to recover 1/4 of the price of the house alleged to have been sold by the first defendant, the claim being based upon a local custom. The transaction between the defendant was ostensibly not a sale but a usufructory mortgage. It was held that the plaintiff, not being a party to the transaction, was entitled to give evidence to show that what purported to be usufructory mortgage was not in a reality such but was in fact a sale. In a case of alienation of the land in which the document has been executed purporting to be a deed of gift or a mortgage, it is open to third party claiming to exercise the right of preemption to prove that the transaction was in reality one of sale and that the document sought to be impugned was executed in order to conceal its real nature and to defraud him of his legal rights. Section 100, saving of provisions of Indian Succession Act relating to the wills. Nothing in this chapter contained shall be taken to affect any of the provisions of the Indian Succession Act as to construction of a will. Act 10 of 1865 replaced by Act 1925. I repeat, Act 10 of 1865 is replaced by Act of 39 of 1925. Section 101, burden of proof. The burden of proof lies on the party who substantially assert the affirmative of the issue and not upon the party who denies it. This rule of convenience has been adopted in practice, not because it is impossible to prove a negative, but because the negative does not admit of the direct and simple proof of which the affirmative is capable. Moreover, it is but reasonable and just that the suitor who relies upon the existence of the fact should be called upon to prove his own case. In application of this rule, regard must be had to the substance and effect of the issue and not its grammatical form. For in a many cases, the party, by making a slight alteration in the drawing of his pleading, may give the issue a negative or affirmative form at his pleasure. It is settled law that the parties are governed by their pleadings, and the burden lies on the person who pleads to prove, and further, the plaintiff has to succeed on the strength of his case and cannot depend upon the weakness of the defendant's case. The party on whom the onus of proof lies must, in order to succeed, establish prima facie case. He cannot, on a failure to do so, take advantage of the weakness of his adversary's case. He must succeed by the strength of his own right and the cleanness of his own proof. He cannot be heard to say that it was too difficult or virtually impossible to prove the matter in a question. For example, mere suspicion is not a proof of benami. The initial burden is upon the claimant to establish that a person is his debtor. Where a party accepts the burden which is laid upon it by the trial court without any demur or protest and allows the case to proceed on the basis throughout the trial, it cannot, when it fails to discharge it, turns around and say in appeal that the burden should not have been placed upon it. The general rule that a party who desires to move the court must prove all facts necessary for the purpose of section 101 to 105 is a subject of two exceptions. He will not be required to prove such facts as are especially within the knowledge of the other party, that deals with section 106, and he will not be required to prove so much of his allegation in respect of which there is any presumption of a law, that is dealt with section 107 to 113, or in some other cases of the fact is dealing with section 114 in his favor. For example, a very old man donated a land and later sued for a possession on the ground that the gift was not voluntary. The burden of proof was upon a donee. The possession of small quantity of the psychotropic substance for a personal use required the prosecution to prove its allegation of commercial possession beyond reasonable doubt. It is enough for the accused in his defense to satisfy judicial mind on preponderance of a probability. Section 102 deals with on whom burden of proof lies. The phrase burden of proof has two meanings. One, the burden of proof as a matter of law and pleading, and the other, the burden of establishing a case. The former is a fixed as a question on the basis of pleadings and unchanged during the entire trial, whereas the latter is not constant but shift as soon as the party adduces sufficient evidence to raise a presumption in his favor. This section lays down a test for ascertaining on which side the burden of proof lies. The section makes it clear that the initial onus is on the plaintiff. If he discharges that onus and makes out a case which entitles him to relief, the onus shift on to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same. There is an essential distinction between the burden of proof and the onus of proof. Burden of proof lies upon the person who has to prove a fact, and it never shifts, but onus of a proof shifts. Such shifting onus is continuous process is the valuation of the evidence. Consistent view of the courts as well as the apex court from the beginning has been that the burden of proof under section 4 subsection 1 of the Prevention of Corruption Act 1947 is cast on an accused person to rebut the presumption created by that section. The burden cannot be equated with the degree and the character of a proof which rests on the prosecution to prove the case, namely the receipt of money as a bribe. The accused may rebut the presumption by showing a mere preponderance of probability in his favor, and it is not necessary for him to establish his case beyond a reasonable doubt. In the case of Chunikor versus Udairam, 1883, 6, Allahabad 73, it was held that in a suit on a bond, the plaintiff accounted for the non-production of the bond by alleging that the defendant had stolen it. The defendant admitted the execution of the bond, but alleged he had paid it. It was held that the defendant was bound to begin and prove payment either by the production of the bond or other evidence or by both. Under section 103, burden of proof as to particular facts. This section amplifies the general rule laid down in section 101. It differs from section 101. By section 101, the party has to prove the whole of the facts which he alleges to entitle him to judgment when the burden of proof is on him. This section provides for the proof of the some one particular fact. The illustration sufficiently point out the meaning. All the facts, however numerous and complicated, which goes to make up the accused's guilt, must be proved by the prosecution. If the accused wishes to prove a particular fact, his alibi, for instance, he must prove it. If the prosecutor wishes to prove the case not by independent oral testimony but by the isolated fact of the accused admission, or if he wishes to throw that in as additional fact, he must prove it. The alibi must be substantiated by the accused. The trial court point out several suspicious throwing considerable doubts about the truth of the plea. The Supreme Court did not interfere. As an instance of provisions of the law that the proof of particular fact shall be upon a particular person. See section 39 of the Code of Criminal Procedure, which says that all person shall give information of the commission of a certain offences to the nearest police officer or a magistrate, and throws upon such person the burden of proving reasonable excuse for not doing so. When a person claims a right of way, he must prove that he acquired the right, and it is for other party to show that he does not have any such right. Where a person is protesting against the nationalization of a route, burden lies upon him to show that the scheme would not serve national purpose. A person claimed that his license could not have been revoked without notice. The burden was held to be upon him to prove the fact, onus to prove the payment of rent lies on the tenant, and mere oral testimony is not sufficient for discharging the onus. Where the defendant alleged that the suit property was a public trust property, the plaintiff did not accept this fact throughout the proceeding. Thus, it became a fact which was asserted by the defendant and was denied by the plaintiff. The court said that the onus of proving the same was on the defendant. The burden of proving a particular fact lies on the party as indicated in the section, irrespective of the fact whether it is affirmative or negative of the issue. In a tort action, malicious prosecution, for example, burden of proving that the plaintiff was prosecuted without reasonable and probable cause is on him, although it is negative of the issue. The plaintiff categorically averred in his plan that the mortgage amount had been tendered to the defendant as also to her husband. The defendant denied it. The court said that having regard to the peculiar facts and circumstances of the case, she should have supported her denial by getting herself examined. Case of Karnataka Transport Corporation versus National Insurance Bank Limited, AIR 1999, Karnataka, page 233. It was held that the claim against the railway for damages to consignment, it was contended by the railway that the damage was due to rainfall, that is an act of God. The court said that a rain is normally an expected natural phenomenon against which a precaution can be taken for saving property. Railway would have to prove that the care and caution was taken, and how it could be said that the operation of nature was irresistible. In a claim against the courier for non-delivery of goods, the court said the burden was not on the plaintiff but on the defendant carrier to prove that there was no negligence on his part. In the case of Habib Ullah Bhatt versus Juna, AIR 2003, Jammu and Kashmir, page 32, it was held that the plaintiff filed a suit for a declaration that the gift deed relating to his property was null and void because at the time of its execution he was a minor. His birth certificate was neither exhibited nor proved through other witnesses. It was for him to prove his age and not for the defendant. The suit was filed 3 years after attaining the majority. He was held not entitled to relief claim.